when you feel like you're nothing, but you wanna be something. Yeah, well, all you really need is hope. I just want you to trust me if you wanna be something.
That's right. Let's go. Yeah, when you're feeling down and you're out, like you got nothing but doubt, you're alone in the crowd, just trying to figure it out. All of this cloud and this money got you feeling left out. Listen up to me now, every word that's out of my mouth. Wake up, it's me. You gonna follow your dreams, or are you just gonna be another cog in the scene? You feel the hope in this beat, yeah, the hope that you need to proceed and be exactly what you want it to be. I feel right and I'm proud, hype and I'm loud. I'ma shout all about how I feel in the now. Ain't nobody ever gonna try to change me till I'm dead, pushing up daisies. I'm alone in the crowd, I won't feel down. I got hope right now, and I know I'll be found. I don't really care just what all other haters gotta say. I know everything I do is gonna make them fade away.
And when you feel like you're nothing, but you wanna be something. Yeah, well, all you really need is hope. I just want you to trust me if you wanna be something. Yeah, then all you really need is hope.
Let's go, it's what you need when you're down, need when you're out. It's what you need when you're sad and when you feel left out. You feel an energy drought and then creeps out, but with a little bit of hope you can figure it out. Keep your head high even when you're down inside. Through the pain you fight and through the painful nights you keep striving, keep trying, keep driving, rising, keep thriving, surviving. Nothing's in your way but yourself, don't need nobody's help. You can make it through this hell, take it one step at a time, one step as you climb. If you fail you'll be fine, get back up to the grind and never lose sight of your mission. Be driven, this life is a prison if you don't have vision. You're in it to win it, so get it, don't miss it. Your chances now, so be something somehow. Don't let yourself down. That's right. Sometimes all we really need is hope.
Hi everyone, how's it going? We are back. back. We have so much to discuss. Elijah Vu, funny, I know, but better hold that wrench tight. Hi Ramblin' Rome, hi Music City Mom, hi Ocean Tide, hello Jordan, hi Angela, good afternoon Roberta, and then, Heather Bratt, hello. So we are going to watch the court appearance for Jesse Vang. Now, hi Kiki's Eyes. Let me show you guys Elijah's update. This is the most recent article. This is from The Independent about Elijah. It says detectives reveal missing toddler was left in dirty diapers and banned from playing with toys. This was just posted 25 minutes ago. It is about the court appearance that we are about to watch. But just to give you a little bit of information, I'm going to read down through this article before we watch this court hearing for those of you who may not be as familiar with this case. So missing Wisconsin toddler Elijah was banned from playing with one toy he had in the week leading up to his disappearance over a month ago. A court hearing heard on Thursday. Detectives who first responded to the Two Rivers apartment where the boy had been staying with suspect Jesse Vang were on the witness stand at the Manitowoc County Court as 39-year-old appeared for his preliminary hearing on a charge of chronic child neglect. There was one toy in the residence which was given to the child at Christmas time, the Sheriff's Office detective said. He gave new details of the tactics used on Elijah. However, during this stay, because it was a punishment, he was not allowed to play with that toy. The 3-year-old's mother, Katrina, had sent the boy to stay with Mr. Vang on the 12th of February so that he could learn to be a man. He was then reported missing 8 days later and has still not been found. These people absolutely disgust me. The fact that they were trying to force this 3-year-old child to learn how to be a man and different things like that is just absolutely devastating and disgusting, the things that this child has endured. And the fact that they are still looking for him. We still have no idea where little Elijah is. They are no closer to finding his location than they were the first day that he went missing, unfortunately. Oops. Definitely don't want to look at this big. They are not the most beautiful people in the world. Mr. Vang allegedly admitted to police much of the tactics he used on Elijah, and some of the detail has been shared previously, including the child being subjected to lengthy timeouts where he was forced to stand for 2 or 3 hours and pray. In court on Thursday, new and expanded descriptions were given by both the detective and the lieutenant from the Two Rivers Police Department, who first responded to the report that Elijah had disappeared. The district attorney asked about the alleged neglect by Mr. Vang, including leaving the boy in soiled diapers. The detective said the defendant claimed that he changed the child's diaper at least one time per day. One time per day. But not necessarily each time it got dirty. Mr. Vang was advised that the child was still bottle fed. He was attempting to get the child to move to more solid or adult style food during this time he was with him. Did he withhold any food from him? The DA asked. The officer stating that Mr. Vang allegedly had kept Elijah from drinking milk. So he's refusing to give him milk while he was there because he wanted him to eat solid foods. Hi, Glowbug. Good to see you. Hi, Cooter G. Hi, BC. Oh, okay, go get Mini Brat. That's fine, I guess, Hi, Dina. Hello, Petunia. Yeah, one time. One time. Yeah, you can't teach a child to be a man when you're not a man yourself. Real men don't hurt children. Exactly. I know, Dina. I know. Diapers need to be changed 4 to 6 times a day, at least. At least. I know. Me too, Roberta. Disgusting humans. It seems like there's no lack of disgusting humans in true crime. Honest to goodness. The cases, the people who cover it, it's just one thing after another. Lieutenant Glasser was then asked about messages between Mr. Vang and Miss Barr, which they discussed Elijah, as well as 2 photos mentioned in an updated criminal complaint in March. The photo depicted Elijah wearing what is believed to be a black blindfold and appears to have bruising on his cheek, necks, and arms. Necks. There's only one neck. He does not have multiple necks. I apologize for making that plural. The officer said that that was taken in the early hours of February 14th, 2 hours after he'd been taken to Mr. Vang's home. The court later heard more details of the threats of cold water made to Elijah. On February 17th, Mr. Vang messaged the boy's mother and said that to say that the toddler had filled his diaper, which made Mr. Vang upset. I recall him stating that he had given Elijah a cold shower and that he appeared to be scared afterwards. The next day, messages between the 2 defendants show that Mr. Vang told Katrina that Elijah didn't respect me. Now I'm making him respect me. He's 3. He is 3. 2 days later, Elijah was reported missing with searches so far only turning up his blanket. They also found a shoe that may have belonged to him. They've never really confirmed that. Despite a previous attempt by Mr. Vang's defense attorneys to overturn the criminal complaint against him, Judge Robert ruled that there was enough evidence to proceed with the case against him. Mr. Vang will appear in court will next appear in a court for his arraignment on the 16th of April, and Katrina is scheduled to appear in court on the 26th of April, also facing the charge of chronic child neglect plus 3 other charges. And so this is what we're going to be watching, this court hearing about little Elijah for Jesse Vang. But just to share his photo, they're ugly mugs. Here's the actual Amber Alert flyer, the official Amber Alert flyer from the National Center for Missing and Exploited Children. He went missing on February 20th from Two Rivers, Wisconsin. He is 3 years old with sandy brown hair, weighs approximately 50 pounds. I don't think this kid was anywhere near 50 pounds, but that's the weight that they have listed here. A child abduction alert has been issued in Manitowoc County for the following child, Elijah Vu, age 3, male, 3 feet tall, 40. This down here, it says 45 pounds. That's probably closer. Up here it says 50. So I'm not sure why there's a discrepancy between the 2 places, but there is. So he has sandy brown hair, brown eyes, a birthmark on the left knee. He was last seen near the 3900 block of Mishicot Road, Two Rivers, Wisconsin, and is missing from Two Rivers. He was last seen wearing gray pants, a long sleeve, dark colored shirt, and red and green dinosaur slip on shoes. Like I said, they did find one shoe, not both. Let me get the actual, I had it up to the spot where it needed to start. And of course, I hit the button and took it down somehow. So we're going to watch the court hearing. I am going to play it on 1.25 so that we can get through it in a little bit quicker time. And then we'll go ahead and talk about the Daybell. I think it actually starts over here. The Daybell jury selection and things like that. I appreciate those of you guys who are here today. Yeah, blindfold on a 3-year-old. What is wrong with people? I know. He's just a little boy. He's just a little boy. I wonder if the guys in jail respect him. Doubtful. Here's the problem. A lot of people say about prison justice and stuff like that. Most of the creeps in jail now, they're all creeps together. Sadly, this is happening so often now that is there really a such thing as prison justice? I know occasionally we do hear stories about that, but I don't know. And then do the prisoners really have access to each other the way that they used to? Not so much. That's why they have tablets and TV and all that stuff now. So here we go.
For CF 162 appearances.
Now, let me audio boost it. Hold on. I'm gonna move it. I'm gonna move everything.
With attorneys Timothy Hogan and Michael Turner.
That is quiet. Closed captioning, as always, is available if anybody needs it. Yeah, they're protected now. So many cretins, and they just protect them now. Not that I want the guards putting their lives at risk, to try to get these guys or fight against them or whatever. But it just isn't prison justice the way that you would think anymore, I guess.
Crystal Lee is present as Hmong interpreter. Ms. Lee, if you could come back to the English channel so we can swear you in. Would you please raise your right hand? Do you solemnly swear that you shall correctly interpret between the court and the parties actually you're not interpreting for the parties, but that you shall correctly interpret from the English language to the Hmong language and from the Hmong language to the English language to the best of your ability, so help you God.
I will.
Thank you. Please state your name and spell your last name for the record.
Crystal Lee, Crystallee.
Thank you. You can go back into the interpretation channel, and just to clarify for the sake of the record, Attorney Bree, your understanding is that Ms. Lee's services are for one of the victims' family members, correct?
That's correct, Judge.
And Attorney Hogan, that's your understanding as well?
It is.
Your client does not need a Hmong interpreter, correct?
Correct.
All right. Matters on the calendar for preliminary hearing today. Attorney Hogan, what's the status?
Your Honor, we are prepared for the hearing this morning. I did want the court to address the motion that I filed. It should be document 26, filed March 18th. I think although I drafted that motion with respect to the original criminal complaint, the arguments are still applicable for the amended criminal complaint, asking that the state make more definite and certain as to the alleged neglectful conduct. If they're unable to, I believe that the criminal complaint is insufficient for purposes of the chronic neglect charge.
All right, which document did you say it was?
26.
There you go. All right, and Attorney Bree, then your response.
Judge, I think the amended complaint that was filed by the state on March 19th of 2024 addresses the concerns that are listed in the motion. And when a court looks at the criminal complaint, it must contain sufficient information together with reasonable inferences that there's probable cause of the crime. And at this point in the process, all reasonable inferences must go to the state. If there's equal inferences, the complaint is still sufficient. In the amended complaint, we have a narrow time frame. We're talking less than 20 days. Obviously, venue's been established. The victim was in the care of the defendant for that time period. There was his own admissions that the victim was specifically transferred to his care on February 12th of 2024. And the conduct while in that care involves multiple instances of these lengthy timeouts as are described, where the victim is asked to stand in a praying position for between 1 to 3 hours, which is very challenging behavior for a victim of that age, not only physically, but emotionally, especially in that kind of position. And this was something that was conducted on multiple days during that time period. The victim was also left alone, unsupervised in that time period, February 16th into the 17th, while specifically the 17th in the early morning hours, while the defendant as well as Ms. Bauer were away from the apartment. The victim is 3 years old and leaving a 3-year-old unattended for over an hour, I think also would qualify as one of the neglectful acts. We also have other evidence listed in the complaint, not only of the disciplinary things, the cold water discipline that was used, the fear tactics that were used, as well as the timeouts and being left alone. I think when you look at all the inferences, the complaint is sufficient, and that's the motion to be denied.
Any response to that, Attorney Hogan?
I stand by the arguments that I indicated in my motion.
As the court views the motion, I'll just address as it relates to the charge of child neglect. It indicates 6 elements. The child is 19, the age of 18. I don't believe that's in dispute. The defendant was the person responsible for the welfare of the child. I don't think that's in dispute. The defendant, through action and for reasons other than poverty, failed to provide necessary care. I think the instances noted by Attorney Bree, as well as the alleged admission in the complaint by Mr. Vang that the child was in his care, he went to sleep and then the child, when he wakes up, is gone. That certainly seems like a failure to provide necessary care. The failure to provide seriously endangered physical, mental, or emotional health of the child. The failure to provide was negligent, and the natural and probable consequences of the neglect would be death, great bodily harm, child sex offense, emotional damage, or bodily harm. I think for the reasons outlined by the conduct described by Attorney Bree, as well as the fact that Mr. Vang allegedly acknowledged that the child was in his care, he woke up, the child was gone, certainly rise to the sufficient level. So the court will deny that motion. What other motions did you want to take up prior to the preliminary hearing, Attorney Hogan?
No other motions to take up.
All right. And your client wishes to proceed with the hearing then?
Yes.
All right. Attorney Bree, you can call your first witness.
Your Honor, the state would call Detective Herman.
All right.
There is a second witness, Lieutenant Glazer, who will be stepping out of the courtroom.
Sounds good. Detective, you please come to the witness stand here, remain standing, raise your right hand. Clerk will administer the oath.
You solemnly swear that the testimony you're about to give in the matter now before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Be seated. State your full name and spell your last name for the record.
Michael Herman, Herrmann.
Go ahead, Attorney Bree.
Detective Herman, how are you currently employed?
I'm a detective with the Manitowoc County Sheriff's Office,
And how long have you been with the Sheriff's Office?
30 years,
And how long have you been a detective?
5 years.
Were you so employed on February 20th of 2024?
I was.
And on that date, did you respond to 3918 Mishcot Road, apartment number 102?
I did.
What municipality is that located in?
The city of Rivers.
Is that Manitowoc County, state of Wisconsin?
It is.
When you responded to that apartment, did you speak with a Jesse Vang?
I did.
And the person you know as Jesse Vang, is he present in court today?
Yes.
Can you describe where he's seated and what he's wearing?
He is seated at the defense table between his counsel, wearing an orange jumpsuit.
Let the record reflect identification of the defendant.
So reflected.
Did you have an opportunity to speak with Mr. Vang on February 20th of 2024?
I did.
And initially, did you speak with him at his apartment?
I did.
When you initially spoke with him, what information did he tell you about the victim, child one?
He indicated that the child was in his care, and that on that morning, he had gone to bed and brought the child with him into his room, closed the door, and that he woke up again at 11 o'clock in the morning and the child was missing.
And when you spoke with him, he indicated that he was in the care of victim child one at that point in time, correct?
That is correct.
Did he give you time parameters as far as when he initially started caring for that child?
He did.
And what time period was that?
Mr. Vang picked up victim child one on February 12th in the city of Fond du Lac at a quick trip from the child's mother, Katrina Bauer.
And how long was he supposed to have the child?
Until the following Friday, the 23rd.
This apartment on Mishcot Road, was that Mr. Vang's residence?
Yes,
And were you able during the investigation to ascertain the age of victim child one?
I was
How old was victim child one?
3 years old.
Did you have an opportunity to have a longer conversation with Mr. Vang at the Two Rivers Police Department?
I did.
Did you speak with him regarding victim child one and the purpose of the victim staying with him from February 12th through that February 23rd timeframe?
I did.
And what did he tell you about why the child was going to be there?
He had indicated that the child's mother was having difficulty with the child and the child's behaviors. An agreement was made between Mr. Vang and Ms. Power that he would assist her with those behavioral issues. An agreement was made that the child's custody would be transferred to him for a period of time to assist with those behavioral issues.
And did you discuss with him how he was going to deal or how he did deal with those behavioral issues?
I did.
And what information did he provide as far as dealing with those behavioral issues?
He indicated that the child would be in timeouts whenever there was problems with those issues.
And did you ask him what he meant by a timeout?
I did.
What did he tell you?
He indicated that he would have the child stand for 2 to 3 hours and pray while he was standing.
Did he give you any specifics as far as body position, as far as how the child had to stand?
He did. He indicated that he would stand and place his hands in a praying position and demonstrated this by placing his hands together in front of his person.
And he indicated that initially we spoke with him that this would go on from 2 to 3 hours at a time.
That is correct.
And while this was happening, was the victim allowed to sit down or do anything else, or did he have to stand for the entire time period?
I was told that he was required to stand for the entire time period.
Did he indicate how often these timeouts were happening?
He had indicated to me that the entire purpose for him being at Mr. Vang's residence was for a timeout. So he did not indicate exact amounts of times during the day, during any given day, but indicated that the entire purpose for his being at Mr. Vang's apartment was as a punishment.
Did he give some time frames, such as, was it the timeouts were the majority of the time, or whether it was a shorter amount of time?
The majority of the time.
Did you also talk to him about other disciplinary tactics such as cold water?
I did.
And what did he tell you about cold water?
I had asked him if the timeouts don't work, what process he would use for addressing the behavioral issues. He indicated to me that he was not sure why. However, the child did not like cold water, so he would give an ultimatum to the child that essentially asking him if he wanted cold water.
And he indicated that that was something the child did not like or was concerned about?
That is correct.
Did you also talk to him about other care of the child as far as physical needs such as diapers, food, those types of things?
I did.
I'm going to start specifically with diapers. Was victim child one potty trained at this point in time?
Mr. Vang advised that he was not.
Did he indicate whether he was using diapers?
He did.
And did he indicate how often those were changed?
Mr. Vang advised that he changed the child's diaper at least 1 time per day.
He didn't indicate that he would change every time he was soiled. It was just 1 time per day on average.
That is correct.
Did you also talk to him about any food needs?
I did.
And what did he tell you?
Mr. Vang advised that the child was still bottle fed, and he was attempting to get the child to move to more solid or adult style food during the time that he was with him.
Would he withhold any food from him?
He indicated that he was withholding milk.
Did you also talk to him about other typical child needs such as activity or toys,
I did.
those types of things? And what did he tell you about those typical child needs?
He was asked about toys in the residence. Mr. Vang indicated that there was one toy in the residence, which was given to the child at Christmas time, and he had helped put that toy together. However, during this stay, because it was a punishment, he was not allowed to play with that toy.
So between that February 12th time period and when you were speaking with him, the victim was never allowed to utilize the one toy that he did have at the residence, correct?
That is correct.
And did Mr. Vang indicate a reason why he wasn't allowed to do that normal activity?
Again, he identified that his time with Mr. Vang during those weeks was as a punishment.
And specifically the timeouts?
Correct.
I have nothing else of this particular witness.
Attorney Hogan.
Thank you, Your Honor. Detective, did you review anything prior to your testimony here this morning?
The criminal complaint.
And that was the only thing that you reviewed?
That is correct.
And when you say the criminal complaint, do you mean the original or the amended criminal complaint?
The amended.
Now, you testified that Mr. Vang told you he started caring for victim child 1 on February 12th,
That is correct.
and it was supposed to last until February 23rd.
That is correct.
And when you responded, that was February, I believe you said 20th?
That is correct.
With respect to Mr. Vang talking to you about the timeouts, you indicated Mr. Vang told you the child had to stand in the corner or stand for 2 to 3 hours.
That is correct.
Did you ask him whether the child was unable to stand for the 2 to 3 hours?
We did pose that question to him, and he had identified that it was not like the child was having trouble standing during those time frames.
So Mr. Vang told you that the alleged victim, child 1, didn't have trouble standing for 2 to 3 hour periods.
He did not indicate either way.
And you testified Mr. Vang had alleged victim, child 1, pray during those 2 to 3 hour timeouts.
Correct.
You testified that Mr. Vang said he would use the ultimatum of cold water, if I heard you right.
That is correct.
And did Mr. Vang ever tell you he used cold water in any way?
During my interview, he denied that.
So he denied actually using cold water?
That is correct.
And did he tell you what this ultimatum of giving cold water actually meant he would do?
He did not.
So it's not as though he told you it meant I was going to pour cold water on him.
He did not mention that.
And you said Mr. Vang told you alleged child victim 1 didn't like cold water.
That is correct.
Did he explain that more as to what he meant by that?
He did not.
You testified Mr. Vang told you alleged child victim 1 was not potty trained
That is correct.
and that he was still in diapers.
Correct.
And I think your testimony was Mr. Vang told you he changed the diaper at least once per day.
Correct.
And did you ask him if there were days where he changed the diaper more than one time?
I do not recall.
You had spoken to Mr. Vang actually at this apartment where this all allegedly occurred.
Correct.
Did you see more diapers at that location?
I did not.
Are you aware if diapers were located at that residence?
I'm aware that a search was conducted of the apartment. However, I am not aware of the contents of that search.
And you testified Mr. Vang told you alleged child victim 1 was still bottle fed,
That is correct.
but that he would try to get alleged child victim 1 to eat more solid foods.
That is correct.
Did he tell you whether alleged child victim 1 actually ate more solid foods?
He did.
He did tell you that alleged child victim 1 ate more solid foods?
He indicated that the child would eat with him and his son while they were eating.
And so when you testified, Mr. Vang told you he withheld milk, he still provided the alleged child victim 1 other food.
That is correct.
You testified that Mr. Vang told you there was one toy in that residence?
That is correct.
Did he tell you what kind of toy that was?
And it was indicated it was something similar to a toolbox.
Did you ask him whether there were books at the residence?
We did ask him if he was allowed to participate in any other fun activities. And again, he had indicated that he was there for punishment and was not allowed to participate in those activities.
So Mr. Vang told you alleged child victim 1 wasn't allowed to engage in fun activities.
Correct.
Did you ask him whether there were books at the residence?
I don't recall if I specifically asked about books.
And did Mr. Vang mention anything about books, specifically children's books?
No.
And since you testified you are not aware of the contents of the search, you wouldn't be aware whether books were actually located at the residence, would you?
Not specifically, no.
Do you recall approximately what time in the day that you spoke with Mr. Vang at that apartment?
I believe it was around 1 p.m.
And do you recall what his demeanor was like?
Calm.
But this was at 1 o'clock in the afternoon.
Correct.
Do you recall when the initial dispatch occurred?
I do not recall.
Do you recall if it was very shortly prior to you meeting with Mr. Vang?
There had been some time that had passed between the time I went to the apartment and the initial call.
Did you listen to any 911 call recordings?
I did.
Objection, relevance.
I think that question's fine. I'll let it answer that question. You can answer.
I did not.
Did Mr. Vang indicate whether there was anybody else in the residence during the time from February 12th to February 20th?
Yes.
And who was that?
Indicated that his son, Raiden, was in their residence as well.
So there was another child living at that residence?
Correct.
Did Mr. Vang say anything about whether alleged child victim 1 was allowed to play with the other child?
That subject was asked, and he had indicated that his son does not typically play with other people. The only contact that child victim 1 had with his son was typically when they were eating.
I have nothing further at this time.
Turn the green phone.
Yes, briefly, thank you. Detective, when you were talking with the defendant about these timeouts, did he indicate whether the victim would get tired or not? The other child that was in the residence, the defendant's child, is he of the capabilities to be able to care for others?
He is not.
Is he even able to really communicate with others well?
He has a very difficult time communicating. Mr. Vang had identified that his son has autism.
I have nothing else, thank you.
Any follow-up to those questions, Attorney Moore?
Yes, thank you, Your Honor. Officer, you were asked a question about whether a diaper needed to be changed more than once a day. How many times would a diaper need to be changed?
Diaper should be changed every time it becomes soiled.
And if it was only soiled one time?
If it's only soiled one time, I can see where it would only be changed one time.
Now, you testified, I think that's in relation to alleged child victim 1 not being potty trained, right?
Can you restate that?
Sure. And when you were talking with Mr. Vang about diapers, that was in relation to alleged child victim 1 not being potty trained.
Correct.
And did Mr. Vang tell you whether alleged child victim 1 was ever able to use a toilet?
I don't know that we asked that question.
So alleged child victim one could have used the toilet sometimes.
Potentially.
And on redirect, you testified that Mr. Vang told you alleged child victim one would become tired from standing.
Correct.
Did he tell you how alleged child victim one showed that he was tired from standing?
He did not.
So he just assumed alleged child victim one would become tired from standing.
I don't know what he would have been thinking at that time.
I have nothing further.
Any follow-up to those, Attorney Lemire?
Not for this witness, Judge.
All right, Detective, you can step down. Thank you.
The state would be calling Lieutenant Glazer.
Lieutenant, you can come on up to the witness stand here, remain standing, raise your right hand, the clerk will administer the oath.
Do you solemnly swear that the testimony you're about to give in the matter now before the court shall be the truth, the whole truth, and nothing but the truth, so help you God? Be seated. State your full name and spell your last name for the record.
Jacob Glazer, last name spelling Glaser.
Go ahead, Attorney Lemire.
Your Honor, just for the record, there are going to be two exhibits that I'm going to be using with Lieutenant Glazer. I've previously shown them to counsel prior to the hearing. I'm going to be asking, once they're moved into evidence, that they be sealed in the record and only accessible by the court and counsel.
Attorney Lemire.
Thank you, Your Honor. I did have an opportunity to review both of those photographs prior to court. We would have no objection to the court sealing those and allowing access only for the court and the attorneys.
So the court will grant that request and then just, I guess, caution the lieutenant when pictures are being handed around. Try to keep them confidential. All right, go ahead, Attorney Lemire.
Lieutenant Glazer, how are you currently employed?
I am currently assigned the role of Detective Lieutenant for the City of Two Rivers Police Department.
And how long have you been with the Two Rivers Police Department?
It'll be 8 years in June,
And how long have you been Detective Lieutenant?
1 year in May.
Were you so employed on February 20th of 2024?
I was.
And as part of your employment, did you respond to 3918 Mishicot Road, apartment 102 in the City of Two Rivers?
I did.
Did you make contact with the Jesse Vang at that residence?
Yes.
And did you assist in this investigation in various aspects, not only interviews, but also reviewing some evidence?
I did.
As part of this investigation, did you also speak with a Katrina Bauer?
Yes.
And when you spoke with Katrina Bauer, did you speak specifically about victim child one and whether he was left in the care of Jesse Vang?
I did, yes.
And what did she tell you about whether victim child one was left in the care of Jesse Vang?
She said that victim child one was left in the care of Jesse Vang on February 12th, 2024.
And how long was the child supposed to be with Mr. Vang?
Until approximately February 23rd, 2024.
And she was the parent of victim child one, correct?
Correct.
And she left him in the specific care of Mr. Vang during that time period, correct?
Yes, yes.
Did she indicate why?
From what she had told me was that it was for disciplinary actions, so that Jesse could, the defendant could instruct further on victim child one's behavior.
And did she talk to you about discipline that was being used in Mr. Vang's home?
Yes, that was discussed.
And did she describe some of the discipline that was used?
She did.
And what did she tell you?
I was told that victim child one, the discipline that was filled out by the defendant was to be set in a praying motion for extended periods, repeating a phrase that victim child one had to memorize, and I believe that was it.
Did you also assist in searching of that apartment in Two Rivers?
I did.
During the course of that search by law enforcement, were any dirty diapers located in the apartment that you could find?
Not to my knowledge.
During the course of this investigation, were some cell phones recovered?
Yes.
And who did law enforcement recover cell phones from?
From several different people, specifically Katrina Bauer and Jesse Vang.
And were they recovered specifically from, let's say, their person, like Ms. Bauer's person or Mr. Vang's person?
Yes.
Were those phones subsequently searched?
Yes.
And during the search of those phones, was law enforcement able to locate messaging as well as photographs?
Yes.
Have you reviewed some of those photographs and messaging?
I have.
I'm going to start, around February 13th of 2024. Were there some discussions between Ms. Bauer and Mr. Vang about her coming to his residence?
Yes, there were.
And during those discussions, was there any discussion on whether she would be able to see victim child one or not?
From my recollection, the defendant advised Ms. Bauer that she would not be allowed to see Elijah. Correction, victim child one.
Did you also look in that time period on the phones for any other documentation such as photographs during that time period of February 13th or February 14th?
Yes.
And was there any, strike that, were any photographs located on Ms. Bauer's phone from February 14th of 2024?
Yes, there was a deleted one phone.
Your Honor, may I approach?
No.
I'm showing you it's been marked as Exhibit 1. Can you review that, please?
Yes,
Do you recognize that?
I do.
And can you just describe for the record what that photograph depicts?
The photograph depicts victim child one wearing what is believed to be a black blindfold and appears to have bruising to his cheek, neck, and arm area.
And that was the photograph that was recovered from Ms. Bauer's phone, correct?
Correct.
And that photograph had been deleted, but it was able to be recovered?
Correct.
Your Honor, I move Exhibit 1 in evidence.
Any objection? No. Court will receive Exhibit 1.
And that was taken in the early morning hours of February 14th of 2024, correct?
Correct.
Did you also review messaging from February 15th of 2024?
I did.
And was there any messaging regarding timeouts from February 15th?
There were.
What type of messaging was occurring on that date?
Is it alright if I reviewed my criminal complaint for the verification on what that messaging entailed?
Would that refresh your memory?
Yes.
And just for the record, is it the amended complaint or the original criminal complaint?
The amended complaint filed 3/19/24.
But ask permission to allow me to review that.
Go ahead.
The messaging on February 15th depicts a picture of what appears to be victim child one standing in the corner wearing only a diaper. The picture appears to be taken from the defendant's bedroom located at 3918.
Did you actually review that photograph?
I did.
Your Honor, may I approach? I provided you Exhibit 2. Do you recognize that?
I do.
And is that the photograph from February 15th of 2024?
It is.
And that was sent from the defendant's phone to Ms. Bauer?
Correct.
At approximately 8:24 p.m.?
Correct.
And just for the record, can you describe what that photograph depicts?
It depicts what appears to be victim child one wearing only a diaper that appears to be full, standing in the corner near the doorway of what is the defendant's bedroom door.
And you've personally viewed this apartment, correct?
I have, yes.
Okay, so you're able to recognize what the rooms look like?
I do, and I recognize it as a defendant's room.
Okay. I move Exhibit 2 into evidence.
Any objection? No. Court will receive Exhibit 2.
During a review of cell phone information for Ms. Bauer and Mr. Vang, did you review information from February 16th of 2024 into February 17th of 2024?
Yes, I did.
And on February 16th, was victim child one still in the care of Mr. Vang?
He was.
And in fact, he had been seen with Mr. Vang earlier in the day, correct?
Yes.
Was there a point in time when there was messaging between Ms. Bauer and Mr. Vang on the evening of February 16th of 2024?
There was.
And was Ms. Bauer coming to the Two Rivers area that evening?
Yes, she was.
And did she send any messaging as far as victim child one in the evening hours while she was on her way?
She did. She told the defendant to put him to sleep.
And looking at the cell phone information, were you able to see where Ms. Bauer's cell phone and Mr. Vang's cell phones traveled the early morning hours of February 17th of 2024?
Yes,
And did Ms. Bauer come to Mr. Vang's apartment?
she does.
And do the two cell phones leave together?
They do.
At approximately what time did they leave? Do you know?
12:30 a.m. on the 17th,
And where do they travel to?
the city of Manitowoc,
And specifically, where does Mr. Vang's phone travel to?
Saucy's Bar in the city of Manitowoc.
Was law enforcement able to make contact with individuals from Saucy's Bar?
Yes,
And was Mr. Vang sitting there?
he was.
And did he have a child with him at that point in time?
He did not.
Did Ms. Bauer's phone stay at Saucy's Bar, or did it travel somewhere else?
He traveled to a quick church located near Calumet Avenue in the city of Manitowoc.
Was law enforcement able to obtain video from the quick trip?
Yes,
And when the video was obtained, was there any video that included Ms. Bauer?
yes.
Was it inside the store or outside the store?
Both outside the store and inside the store.
And when that video was reviewed with her inside the store, was a child with her?
No.
And when the video was reviewed, when she was sitting in a vehicle in the parking lot, was a child observed with her?
There was no child there.
Was there a point in time when Ms. Bauer went back to the area where Mr. Vang was at the bar?
There was.
And did both of them travel back to Two Rivers?
They did.
Roughly, when did they get back to the Two Rivers area?
Based off their cell phone data, it shows the two of them meeting back up at approximately 1:55 in the morning and then traveling back to the city of Two Rivers.
So with travel time from Manitowoc to Two Rivers, it's after 2 a.m. by the time they get back to the apartment, correct?
Correct.
Did law enforcement try and determine if anyone else was caring for victim child one during that time period between 12:30 a.m. and approximately 2 a.m.?
Yes.
And during that time period, was law enforcement ever able to find anyone who was caring for that victim child one?
We were not.
Did Ms. Bauer stay in Two Rivers or did she leave?
She left.
And she left in the early morning hours?
Yes, in the early morning hours, approximately 5 in the morning on the 17th.
And she was traveling back towards the Wisconsin Dells area, correct?
Correct.
And in fact, there was a point in time when she was stopped, correct?
Yes.
And were any children in her vehicle when she was stopped?
No.
Did you review any messaging between Mr. Vang and Ms. Bauer related to February 17th of 2024?
I did.
And specifically, I'm going to the time period of 6:39 p.m. What was the messaging about around that time period?
I believe the messaging was about victim child one filling his diaper and the defendant being upset about it.
And what did you do as a result of victim child one filling his diaper?
I recall him stating that he had given victim child one a cold shower and that he appeared to be scared afterwards.
So as a result of the overfilled diaper, he was given the cold shower and that the child was scared, correct? Okay. Did you also review messaging from the time period around February 18th of 2024?
I did, yes.
Was there a discussion between Mr. Vang and Ms. Bauer about victim child one in the early morning hours?
There was.
And what was Mr. Vang telling Ms. Bauer?
As far as I referenced the exact quotes from these messages from the amended criminal complaint,
Would that refresh your memory?
it was, yes. On the morning of the 18th of February, the defendant messages Ms. Bauer telling her that to trust him and that he's going to make sure that he hates him being at his residence. And Ms. Bauer responds that she does not want him to hate the defendant, just to fear him. And the defendant responds saying, "It's okay, someone had to be the bad person." And Ms. Bauer responds by saying, "I know, but either way, he can fear you and respect you." And the defendant responds, "He did fear me, but he didn't respect me. Now I'm making him respect me."
I have nothing else at this point.
Attorney Louise.
Thank you, Your Honor. Officer, did you review anything prior to your testimony here today?
Yes.
And what was that?
The amended criminal complaint, as well as additional reports that reference the criminal complaint.
So you, prior to your testimony here this morning, you reviewed other reports?
Specifically my own.
And when did you review that report?
This morning when I came in for duty.
And do you have a copy of that with you?
I do not.
And where is that report now?
That would be located at the police department in Two Rivers.
And you reviewed that in preparation for your testimony here today?
I did, yes.
Your Honor, I've asked if the state has a copy that they could provide to us.
Attorney LeBrie?
I don't have one in the courtroom. I would have to go upstairs to see if we can obtain one.
Is that what you want to do?
I'm gonna ask a couple of follow-up questions. Officer, how long is that report?
I believe it's 9 or 10 pages.
And does that detail the investigation you did on a particular day or sort of total summary?
It's more so in regards to the interviewing with Ms. Bauer.
Okay, so the report that you reviewed was in relation to your report regarding your interview with Ms. Bauer?
Correct.
Your Honor, I would ask that we be provided a copy of that report.
All right, we'll take a minute here and allow the state to get that. So we'll go off the record and we'll be in recess for some period of time, I guess.
Judge, Ms. Vendetti's here. She can go up and try to obtain it.
And if preferable to the court, while that's being done, I could ask additional questions. If the court wants to take a break, I'm okay with that as well.
It'd probably be good to take a break anyway, because I gotta get a Attorney LeBrie on for the 11:45. So we'll take a recess and we'll take a break right now. Attorney LeBrie, let's go talk to my JD because she's talking about the 11:45. People who are logged in for the 11:45, just sit tight for a second. It's likely this is gonna get. Oh, there's Attorney Larson. Attorney Larson, what can you tell me about your contact with Marina?
Judge T asked if it could be moved to this afternoon, but I'm in some contested prelims this afternoon. I just asked her. I think normally I wouldn't, but I think there's 2 items that are.
Tomorrow at 9 o'clock. You'll be able to log in using the same Zoom instructions used today. We're just in the middle of a hearing that was supposed to start at 11, didn't start till 11:15 because of take whatever amount of time to look at it and then let me know when you're set to go.
Okay.
Yeah, the worst kind of woman. Absolutely. I don't know. Get to. Here we go.
Oh yeah, we got this on Zoom. Oh, Jesus. Okay, so my understanding is there was a short period of disconnection. Yeah, the interpretation channel got axed. Miss Lee, are you still there?
They were having technical errors.
Did I get disconnected again?
I can hear you, Judge, but I know the interpreter cannot hear you. Miss Lee, can you hear me? I don't think she can hear me either.
Well, that's weird.
Oh, you can.
Wait, she can hear you, but she can't hear me?
I can hear you a little bit on Zoom now. You're kind of soft.
Huh. This isn't great.
Yeah, but I can't hear Miss Lee on Zoom or not on Zoom, but on my FTR right now when she's talking.
Mr. Boo's got a thumbs up going. I don't know if that means he can hear her. So Lisa, I'm not coming through clearly to you?
On Zoom, you're cutting in and out.
Jeez.
But I can hear you on the FTR.
Okay.
And right now you're just a little soft on Zoom.
Judge, I can hear you. I'm not sure if you can hear me, but
Yeah, I can.
I'm not hearing anything from the interpreter at the moment.
Okay. Ms. Lee, can you hear
Okay,
anybody?
I can hear her.
You
Yes,
can-
Mama.
You can hear her again?
Yep.
Can she hear me?
Couple of Judge now. No? Okay. Okay, so she can hear me, but she can't, yeah, she can hear you, but, when she talks, I can hear her.
Oh, wait.
Can you
Try
hear me,
this.
Josh?
Yeah.
Can you hear me?
I
Okay,
had to get back into the English channel. Sorry.
okay. Oh, it's
I got
okay.
disconnected. Okay, Lisa, you can hear me better on Zoom now?
I can, Josh, thank
Okay,
you.
and Miss Lee, you can hear me on Zoom?
Yes, I can, yes. Can everyone hear me okay?
Okay, so, Mr. Vu, you can go back into the interpretation channel, then Miss Lee, you can go back into the interpretation
Okay,
channel.
sounds good.
I think we should be set.
Okay.
Fingers crossed. We'll go back on the record. Attorney Hogan, you've been provided a copy of that report then?
Your Honor, I would note for the record, I was provided 2 pages of the report. There was some discussion between the attorneys and the witness. The witness had clarified that he'd only reviewed essentially 1 paragraph that separated onto 2 pages in preparation for his testimony. That's what I was provided and had an opportunity to review.
Okay, so let's nail that part down with the witness, because the court's recollection of the witness's testimony is he reviewed a 9-page report. So I guess Attorney LaBrie, if you want to clarify that, then well, wait, Attorney Hogan, you were asking. Yeah, I guess you can go ahead and ask some questions about what you've been given, Attorney Hogan, and whether that's what he reviewed or not, and we'll go from there depending on the answers you get and what you want to tell me.
All right, thank you, Your Honor. Officer, I'm looking at 2 pages of a document that I think you had an opportunity while we were on break to review. Is that correct?
Correct, yes.
And I believe I overheard you telling someone from the district attorney's office that there was essentially 1 paragraph and that was all you had reviewed.
Correct, yes, specifically about the photograph portion there.
Okay, prior to going on break, I asked you some questions about what you had reviewed,
Yes.
and you had indicated your report.
Yeah, I was referencing that specific report, yes.
Okay, but you didn't indicate at that time that you'd only looked at essentially 1 paragraph of that report?
Correct.
But your testimony here right now is that you did only review that 1 paragraph?
Correct.
You testified that you assisted in the search of the apartment
Yes,
and no dirty diapers were located?
correct,
Did you locate any clean diapers?
yes.
How many?
I don't recall off the top of my head. I believe there was at least 1 box that was found.
1 box of clean diapers.
Yes,
And was there any sort of unsanitary conditions in the residence?
No.
There wasn't like garbage all over the place?
no, it was a well-kept apartment.
And were you made aware at all of when garbage had last been taken out of that residence?
I don't know for sure. There was garbage in a garbage can that was still there.
And how full was that?
Half to 3/4 full, I believe.
And did you search through that?
It was searched through. I did not do that myself.
Do you know if there were any soiled diapers in that garbage?
I do not believe so.
You testified that you reviewed a number of messages and photographs on some cell phones?
Correct.
And you testified about exhibits 1 and 2, and those were both photographs. Were both of those photos located on Katrina Bauer's phone?
No.
Which was exhibit 1 located on Katrina Bauer's phone?
Yes,
And exhibit 2 that was located on Jesse Vang's phone?
it was located on Facebook Messenger, sent from the defendant, yes.
Okay. And exhibit 1 was actually in the photo section of the phone?
Correct, extracted from Ms. Bauer's phone.
And you testified in exhibit 1 that alleged child victim 1 is wearing a black blindfold?
Correct.
And there's some bruising that you're able to observe?
Correct.
And were you able to determine when that photo was actually taken?
Yes, based off of the timestamp from the phone extraction
And when was that?
on the 14th early morning hours.
And that was actually taken on Katrina Bauer's phone?
It was, and it showed GPS location of the defendant's apartment.
And in exhibit 1, you can see alleged child victims sort of side face.
Yes, the right side.
And I believe his right arm, part of his right arm.
Correct.
I believe exhibit 1 shows alleged child victim 1 with a blanket
Yes.
on some type of mattress or bedding or some sort.
Correct.
So not laying on the floor at all,
Correct.
covered up with a blanket partially.
Yep.
With respect to exhibit 2, you testified that shows alleged child victim 1 standing
Yes.
from a distance away from the camera.
Correct.
And you testified that alleged child victim 1 is wearing only a diaper.
Yes.
And that was taken, the photo was taken February 14th, I think you said?
This is the photo of the child victim one standing in the corner.
Correct.
I don't believe that was the date that photo was taken.
Do you recall the date that that photograph was taken?
I don't have the origin date of that photograph. I just am aware of when it was sent via Facebook Messenger.
And what date was it sent?
That was sent on, is it all right if I refresh my memory with a criminal complaint for that photograph?
If that would refresh your recollection.
Thank you. That would be February 15th.
February 15th was the date it was sent?
Correct.
And you testified that that was sent on Facebook Messenger from Jesse Vang's Facebook to Katrina Bowers?
Correct, yes.
And in that photograph, you can see alleged child victim 1's skin.
Yes.
And are you able to observe any sort of bruising or other injuries in that photograph?
Can I refresh my memory by examining that exhibit again?
If you want to take a look at exhibit number 2.
I cannot.
You cannot locate any bruising or other injuries in exhibit 2?
Correct.
And are you able to tell if that photograph was taken in the daytime or at nighttime at all?
It appears to be daytime.
Now, you testified that you were able to observe some phone activity and location data from some cell phones in the early morning hours of February 17th.
Correct.
And I believe you said Katrina Bowers' phone shows her phone arriving at Mr. Vang's residence in the early morning hours,
Yes.
and then leaving that location at the same time Mr. Vang's phone is leaving.
Correct.
You testified that you observed some video surveillance from that date,
Yes.
and that was from Quick Trip,
Yes, it was.
and you saw Katrina Bauer go into a Quick Trip.
Yes.
Were you able to observe inside of the vehicle,
Yes.
like the entirety of the inside of the vehicle?
Based off of different frames we were able to take and look inside the vehicle to observe all angles.
And you testified that the phones got back to Two Rivers at some point after 2 o'clock in the morning.
Correct.
And so between approximately 12:30 in the morning and 2 o'clock in the morning, through your investigation, there was no evidence of alleged child victim 1 having left the residence in that time frame.
Correct.
And I believe you testified that law enforcement was unable to find anyone caring for alleged child victim 1 during that time.
Correct.
And did you ask Katrina Bauer about that time frame?
We did, yes.
And what did she tell you about that time frame?
She was not able to give us a lot of detail on that time frame initially, as that was, she declined to initially give officers details regarding that time.
Did you or other law enforcement ask Mr. Vang about that time frame?
I specifically did not.
Have you taken other steps in attempting to identify anyone else who may have been at the residence during that time frame?
Yes.
And what kind of steps were those?
There were several interviews that were conducted through many of the other residents that are located in the apartment complex, which the defendant resides in. We've gone through, again, many phones and Facebook Messenger to determine if there was any care or conversation of care to be had during those times.
Were you able to determine whether there was any other person in the residence at that time?
We were not.
Are you aware that Mr. Vang has other children?
Yes.
Specifically, are you aware that Mr. Vang has a son that lives at that residence?
Yes.
And were you able to determine whether Mr. Vang's son was at the residence during that time?
It was assumed.
And so there was at least an assumption on law enforcement's part that there was at least another human being at the apartment.
Yes.
You testified that there was some messages from later on the date of February 17th that you reviewed,
Yes.
and one of them was with respect to alleged child victim 1 filling his diaper.
Correct.
And that Mr. Vang had messaged that made him upset.
Yes.
And that Mr. Vang's message said that he had given alleged child victim 1 a cold shower.
Correct.
Did you or other law enforcement ask Mr. Vang about that message?
This was after he had already been taken into custody, that was determined.
Do you have any evidence that Mr. Vang, in fact, gave alleged child victim 1 a cold shower on that day?
Other than the messages, we not.
So it's just a message that Mr. Vang had said this is what he did, but you don't know if that actually happened.
Correct.
You testified that there were some messages in the early morning hours on February 18th.
Yes.
And something along the lines of Mr. Vang saying that he was going to make alleged child victim 1 fear and respect him.
Correct.
In any of the messages that you reviewed, did you review any messages of Mr. Vang saying anything in relation to he was going to physically hurt alleged child victim 1?
To my recollection, no.
Any messages that he was attempting to not provide food to alleged child victim 1?
No messages.
Any messages related to anything specific about physically harming alleged child victim number 1?
No.
I have nothing further at this time.
Attorney Bruce.
Thank you. Lieutenant Glazer, the photograph in Exhibit 2, you see the back of victim child 1, correct?
Correct.
You cannot see the front, the face, the neck, anything like that, correct?
Correct.
You can't see the elbow area that's depicted in Exhibit 1, correct?
Correct.
So the only thing you're able to view is the back of victim child 1, the back of his legs, and part of the back of his arms, correct?
Correct.
Whereas in Exhibit 1, you can see the injuries to the neck, the face, and the arm, correct?
Correct.
You were asked about February 17, 2024, that it was assumed that the defendant's son was in the residence during those early morning hours of 12:30 in the morning, correct?
Correct.
That individual, the son, can he care for another child?
No.
Is he even able to speak?
He is nonverbal.
Would he be able to, based upon his limitations, provide care for anyone else?
No.
And you were just asked some questions about the messaging from the 17th, about the cold shower. And that messaging indicated that victim child 1 was clean after the shower, but also that he was scared, correct?
Correct.
I have nothing else, thank you.
Any follow-up to those, Attorney?
No.
Lieutenant, you can step down. I'll take you to the 22 for me. Any other testimony, Attorney Brew?
No, just thank you.
Any testimony, Attorney Owen?
No.
Argument, Attorney Brew?
Your Honor, the state would move for bind over. I think we have sufficiently shown probable cause that a crime was committed and that it's probable that this defendant committed it. We have a specific time period in February of 2021. These incidents occurred in the city of Two Rivers. The victim was 3 years old, so he would be under the age of 6 that is required as far as the charging. We have multiple acts that could fit under the chronic neglect. There were multiple timeouts. We have those documented by the defendant's statements, photographs, as well as the messaging. There's also concern over proper physical care as far as the diaper. There's statements regarding potentially changed once a day. We're not finding dirty diapers in the garbage, but we are finding messaging about the child overflowing his diaper, and the photograph which shows a full one. There's the cold water threats as well as utility during the cold shower, which left the child scared. And furthermore, the child was left alone on that February 17th date without supervision for over an hour. I think at this point, at a preliminary hearing, all inferences go to the state. I think we have sufficiently shown probable cause. Thank you.
Attorney Owen?
Your Honor, we're going to ask that the court not find probable cause with respect to the February 17th incident of alleged child victim one being left home without no supervision. I don't believe that the elements have been met at that time. The testimony is that the child's mother was actually at the location and ended up leaving with Mr. Vang. And given that the child's mother was there at the time, possibly it was not Mr. Vang then being a person responsible for the welfare of the child during that time frame, as the victim's mother was present at that time and location. However, even assuming the court finds that at that time he was a person still responsible for the welfare of the child, there's just as much evidence to suggest that he was supervised as unsupervised. I think the testimony was we were unable to locate anyone who had been supervising the child or been at the residence during that time frame, and law enforcement made other assumptions as to other people who had been at the residence during that time frame. With respect to the condition of the apartment, the testimony is that there wasn't any unsanitary conditions at the residence, that it was generally a well-upkept apartment, that when the search of the apartment was conducted, it was generally clean. One of the garbages was about half full. The officer testified that he wasn't aware whether any dirty diapers were located in that garbage. Even assuming that the photograph shows in exhibit number 2, a soiled diaper, the testimony is that a photograph was taken days prior to the search being conducted. There is testimony that Mr. Vang admitted to changing the diaper at least once per day. No evidence to suggest that alleged child victim one's diaper necessarily needed to be changed more often than that, or that even if it did, that Mr. Vang didn't change it more than once. We have the testimony suggesting that at least once per day, which leads to the reasonable inference that on more than once per day it was also changed. So I think based on the testimony presented today, there is not probable cause to believe that Mr. Vang committed the offense charge, and we would ask that the court dismiss.
The court's charge at the preliminary hearing stage is to determine if there's probable cause to believe a felony was committed and the defendant committed it. When looking at the testimony in giving the reasonable inferences, finding the reasonable inferences in favor of the state, what I think kind of ties it all together here is testimony regarding text messages from February 18th, and specifically the defendant messaging Ms. Bauer that I'm going to make sure he hates me and being here. The message that he did fear me. He didn't respect me. He didn't respect me now, and then he didn't respect me. That tells me that the reasonable inference there is that Mr. Vang is carrying out actions that are designed to instill fear in the child. He acknowledges as much. I don't think one can reasonably make the argument that Mr. Vang is not engaging in conduct which could result in emotional or mental harm to the child when he's specifically stating he's doing it in order to get the child to fear. Like I say, that's what ties it together. But the testimony in the record today, specifically referencing exhibits 1 and 2, it's full of evidence that supports finding probable cause here. So the court will find that there's probable cause to believe a felony was committed and Mr. Vang committed it. I'll bind him over for further proceedings. Is this state anticipating filing an information with charges that mirrors that in the amended complaint?
Your Honor, I'm asking for an arraignment date. I don't need a long amount of time.
All right.
I'm fine with doing that assist defense counsel too.
I'm out next week, and parties have time on the 16th.
Depending on time of day, yes.
I would hope 10:30.
April 16th at 10:30?
Yeah.
I actually believe counsel and I are in a motion hearing at that point.
Oh.
It's in branch 1 though, so we're.
Do you anticipate, how long do you anticipate that taking?
I think less than a half hour, correct?
I have pleading this point 11 that we can either do this on the front end of if you're done before the half hour's up, or as soon as that's finished, because I don't think it'll take a full half hour.
I would say it would probably be safer on the back end because that motion is a motion to dismiss and then approve.
All right.
So if we did like 11:15.
Okay. Can you guys do 11:15?
That works. 11:15 works.
So we'll set the arraignment for April 16th at 11:15. Just 1 second here. Attorney Hogan, you also had well, your client also filed a form modification request. Did you follow up with one of your own or not?
We did not. I thought I mentioned it at the last hearing. If I did not, I apologize. At this time, we were withdrawing that request.
All right, no good. Anything else for the record then today, Attorney LeBrie?
No, Judge.
Attorney Hogan?
No, thank you.
Then we're adjourned. Thank you for everyone's patience. So the folks who were logging on for Vang, that hearing's concluded.
just make our own agreement, they don't work out for you. And this isn't going to work out so well for him because he's going to find out all of a sudden they have control over everything, being the way it's been established, where she's been able to keep the majority of the decisions. Because obviously he's been left out of the loop. That means she's been setting the parameters at the school. She's been setting the parameters with CPS. She's been setting everything. So she's basically put herself in charge as the sole custodial. And that's not going to be fair to him. And it's going to be heartbreaking to him at some point when he finds out realistically what really goes down in the court system, regardless. So he needs to really.
Oh, goodness. Took me a second to get, no, you're good. Took me a second to get back to the computer. Okay, let me get Nate Eaton up. Okay, jury selection, of course, is where we're heading next. You just got excited for a second that we weren't going to stare at motionless Chad, but boy, were you wrong. Sorry. Okay, so let me see. I want to pull up Nate Eaton first, actually, because they are on break right now, in all actuality. See, court will resume shortly. They're taking their 15-minute afternoon break, which is perfect, actually, because we will just go to Twitter, X, whatever in the heck this is, and we will figure out where we are. And so they are on the second group of jurors. In the second group, there was 9 men and 6 women. One juror failed to appear, so that's the second time this has happened for this case. And They are now telling the jurors 8 to 10 weeks. I know originally they were saying 10 to 12. So now they're saying 8 to 10 weeks. They are also saying that they will be done by 3:30 p.m. each day, is what they're telling the jurors who are inquiring because of young children and different things like that. Now this morning, let me see if I can get an idea of how many they have sat so far, is my goal here. Apparently they went through a quiet period this afternoon because all of the audio dropped. Really odd because that also happened during Jesse Vang's court. So 7 jurors from this morning advanced. 3 men and 4 women. They will now be brought back in and advised not to read or watch anything else in the case. This afternoon, another group of 16, which we know is 15, will come in. They only need 6 more before we hit 50. So we only need 6 more people, and they are asking questions of 15. Now I wonder how many were initially removed. Each day sequestration is possible. So it says court will be finished at 3:30 p.m., but each day being sequestered is possible. The woman would not be able to be without her family for 1 to 2 weeks. So it sounds like they had somebody at least. I may have to go and watch like their lunch, somebody's lunch recap. Let me see if I can find let me see if he did a live stream during lunch break, because I freaking hate Twitter. Why is everything so jumbled? Why can't it just go like in order? That would be fantastic. Let's see. Did she do a lunch live?
Stay with me because I'm going to let you guys know something I learned yesterday.
This is Hidden True Crime. For those of you guys who have not been following her, she's amazing. She's there in person this week. Don't watch her stream it on her channel. She's not there. She won't be talking to you. Watch it here. I'll talk to you. We can definitely watch her during the breaks and things like that, but don't go there. Yeah, we'll probably have opening statements Monday, if not tomorrow. No, because they'll narrow it down to out of the 50 to the 16. So it could be tomorrow afternoon or early Monday, depending. Yes, we are so close. So here's Hidden True Crimes link. Let's watch. This is her lunch live.
Today. I don't know if anybody's here yet. It seems like the delay is getting longer and longer when I turn this live on. It takes a little bit longer for it to go than it did last year. Let's see if anybody's here. Okay, here we are. Hello. All right. Stay with me because I'm going to let you guys know something I learned. One of, or the Chad Daybell's nickname at Madison County Jail. I've got that for you guys. So just wanted to give a quick update. It is raining. It is pouring here in Boise, Idaho. So I'm standing under this, there's a little bit of a shelter right there. So that's why I've got that going. I'm wearing my earbuds because that's what you guys opted and said was better. So I've got my earbuds in. Guys, we are on 44 potential jurors. That is very exciting, especially since we just need to get to 50. And I was guesstimating just a couple days ago on Tuesday, I was thinking that opening statements would be April 15th, 14th. That's what I was guesstimating. And now I'm realizing that they're probably going to be Monday. They could really, truly be Monday, especially if we get to 50 potential jurors today. And what that means, once we get to 50, people wonder we need a total of 18 in the end, right? Again, 12 jurors plus 6 alternate. Although they won't know who's alternate and who's a juror, they'll all be jurors. 18 jurors that will need to be in the courtroom during Chad Daybell's trial. So we are getting so close. We, after Tuesday, getting about 3, I was really worried. But now, like I said, we are at 44. We started the day at 37, so we've already reached 7 before lunch. So if we can get 6 more by the end of the day, those are 50. And then what happens is each the defense and the prosecution then strike who they don't want to be a juror. They each put in their strikes, and then whoever's left are jurors for the trial. And then again, opening statements could start as soon as Monday now. I think it's wild. With that being said, you guys noticed that I bowed out for a little bit. I was in there and I took off. I went to a doctor's appointment. I'm okay. I'm fine, but I have not been feeling well. And so what I'm going to do is head home after I'm done with this lunch live and watch the rest of the day on chat with all of you from home, because we've got to prepare for the days ahead. And I've got to make sure that I am good to go and healthy, because I want to be there every single day and see this through. So thank you, Brady, for liking my interview with the two Lori jurors. We have some more interviews coming up and in the works. And this hidden hour, by the way, Saturday night, we have a very special guest. It's not going to be Dr. Don. I'm sorry for those that will disappoint. But he has not been able to keep too much update on the jury selection because he's been holding down the fort at home. But I will have a very special guest, and I think it's going to be a very, very worthwhile show. I'll share more later. John Pryor today continuing his emphasis on all that glitters is not gold. He got so into it. I don't know if I've heard the word glitter so much. I wish, it makes me wish I maybe brought some of my jewelry with me. I did not, trying to simplify things while traveling, but I could be wearing glitter in there every day, but alas. So again, like I said, I definitely think that what he's referring to when he asks people if things can glitter, and that glittering is, not all it's cracked up to be. Don't trust things that glitter. He's definitely talking about Lori Vallow Daybell. This is definitely, like I said, going to be his argument, which is the woman did it. Blame the woman, blame the mother of the children. Chad.
Because Chad's just a man, and he couldn't control himself around all that pretty woman. Come on, that's like the most lame excuse ever. Have some self-control, Chad.
Believed her, and she was a deceptive little one. And yes, Chad Daybell lied about his affair because nobody's completely honest, right? Nobody, because that's what he also asks each and every juror. You guys haven't been honest about everything in your life. Certainly, if somebody's having an affair, then they would certainly probably lie about that, right? So I think we're just seeing his entire strategy laid out before opening statements, and that is innocent Chad lied about an affair, but how many men have affairs and lie about them? And in the end, she was this really glittery being, so glittery she was even maybe translated at a goddess, but it was just all a deceptive ploy to get him to bury for children in his yard. And those heartless photos that you'll see, the photos that will break everybody's heart, all those jurors' hearts. Well, you can't possibly blame Chad Daybell for the emotions that you feel when looking at these photos. Are going to break your heart, despite them, again, being in Chad's yard. So I think we're seeing that's where he's going. So we'll to be determined how this goes and how the jurors buy it, and it'll be interesting to see who ends up being jurors. All right. So for the thing I said to wait for it is I learned from a very reliable source what some of the officials in the Madison County jail call Chad Daybell. You ready for this? They call him Slug. Slug is his nickname. Slug, because of the way he moves and his posture and the way he asks for things and the way he kind of slugs away and the way he moves his head. Slug.
Oh my God, Slug? That's so funny. They call him Slug? Oh, geez.
So we are about to head into the opening statements, probably sooner than we thought, of Slug Daybell's trial. Don't worry, I won't be that. I will call him Chad. Chad Daybell's trial. But you can all now know that Minnie and Madison County know him as Slug. With that, I'm going to take off. I'm going to go grab my Uber and head home, rest up with some medication that I just got. I'll be fine. And maybe change into some cozy pajama pants and watch the rest of this jury selection with all of you right here on chat. And maybe we get 6 more this afternoon. Here's the hoping. All right, we'll see you guys. Bye.
I'm making a slug emoji, like it's happening right now. I'm gonna make a slug emoji and put Chad's face on it. Oh, man. Was looking to see if Nate did if he did a little upload or anything during lunch or during break, I mean. Judge John Judge is live also with the Coburger hearing. Oh, that's been on for an hour. Holy smokes. I forgot all about that one. Yeah. Oh, yeah, we're gonna have a slug emoji. It'll probably be this guy. Probably put this guy. Who wants to put Chad's face creatively on this thing? Yep. Oh, yeah. We need a new emoji. You call him Glittery Slug. We'll just put him a slug with like a glitter background, maybe. Oh, man. Every case has its emoji. Dun dun dun. Do the slug from Star Wars. What's that one look like? Oh, Jabba. You want me to use Jabba the Hutt? That does kind of look like him, come to think of it. Hold on one second. I'm getting it. I gotta delete an overlay. I got too many overlays again. Delete some of my jury selection overlays that I had. Delete my eggs. Here we go. Oh, where'd it go? I thought I just saved it. I guess I didn't. Hold on. Hold on. Saving as a web file. Hold on. It's gonna make me open it a different way. Bah, bah, bah. What are you doing here? Here we go. This guy. Oh, not the spaghetti monster. How'd that even get up there? Chaba the nut. Oh no. Jordan. I have Chaba the nut standing there like this, worshiping his glittery lorry. Beat him. What? What's wrong with Chaba the Hutt? Yeah, this is the best part of the day. This is the best part of the day. Jury selection. How could anybody not want to sit through all of this? Let me see here. So BC just sent me this. It does have the live play-by-play updates. We can read down through. Let's see. Yeah, afternoon break. Sorry, the kids are like playing hide and go seek and running in the hall and all that stuff. They're just playing. Dinner time is a bad time for me to have to unmute. Let's see here. So, I mean, it looks like, I don't know how many they have dismissed. Like this one talks about, wish I would say how many. So 4 members heard of the case before the individual voir dire. Let's see how many. Mommy. Okay. It says one juror has failed to appear, asked the 15 who they are there to hold up their red cards showing their numbers. He introduces himself. The clerk takes roll call. The juror who failed to appear has until 5 p.m. to get here or provide good explanation why they didn't show up. If they don't show up or have a reason, they'll receive a $500 fine and up to 5 days in jail. They are not playing about not showing up to this jury selection, you guys. Boyce explains that the state has the burden to provide Daybell with guilty beyond a reasonable doubt. The defendant never has to prove anything. The Daybells never need to take the stand. Boyce reads the instructions to the jury. He explains that they may be dismissed for cause during peremptory challenges. He tells them not to feel offended or that their honesty and integrity is being questioned. He asked if them serving 8 to 10 weeks would create a financial hardship for any of the jurors. One man says he spoke to HR and they will only pay for 2 weeks of jury duty. So they dismiss that guy right off the bat. So that guy is gone. The next person also is dismissed. So that takes us to 13. 4 people have already heard about the case. They'll ask them about that individually. So we're 13. We could possibly go down to 9. We only need 6. And we have one guy who raised his hand and said that he has 2 very young children and thinks that it would be very difficult for him to see images. He says he would struggle to not make an immediate opinion, but also would be willing to listen. However, he worries that he could not be impartial after seeing them. Then she told her cheesy eggs story. She talked about the Kansas Chiefs winning the Super Bowl. So one man says that he has a problem with the conspiracy definition and believes that a person would have to actually commit the crime, not just talk about it. Blake asks him a few questions and then motions to have him dismiss. Pryor asked to approach. The attorneys and Boyce met on the side of the courtroom while the white noise played. Boyce, back on the bench, says he will take the motion under to advisement for now, but the man stays and another lady raises her card and says she feels one party can manipulate the other 2 parties. Blake has no further questions. Pryor will now question the group. Chad Daybell is looking at the jurors. Pryor says he wants the jurors to understand that there are no wrong answers. The court lost audio for a little bit. And then Pryor says, I am a lucky man. I have an absolutely gorgeous girlfriend. I think dearly of her, and I don't deserve her. I don't know if she would marry me or not, but we skirt about the issue a lot. He asks the jurors to raise their hand if they think he has made an offer of marriage to her. Nobody raises their hands. Pryor asks if one on the jury has been 100% honest their entire time. He says people tell lies all the time and asks the jury if people lie about relationships. Many say yes. Pryor's now bringing up the line from the country song, everything that glitters is not gold. He asks the jury what they think of the expression could mean. So that's it. And then they go into the break, basically. And the young children issue. Yeah, not the cheesy eggs. Yeah, $500 fine and up to 5 days in jail. Mom life, you ain't kidding. Great news, they're back.
Sir, so did you have anything to add to that?
Oh, no.
Okay.
That's fine.
So if I'm understanding correctly, you hold a conviction that, proof should be beyond any possible doubt whatsoever.
Yes.
And if I'm understanding you correctly, you'd have a difficult time following the judge's instruction if the instruction was proof beyond a reasonable doubt is not a possible doubt or an imaginary doubt. Is that fair to say?
So like,
It's okay. It's totally okay. Totally okay.
I'm not sure I'm just fully understanding the.
Okay, so let me ask you this. Are you saying that, well, let me ask you a different question. Even if you held a personal belief, that, there should be proof beyond any and all doubt, not even, like, even proof beyond even a possible doubt, proof beyond even an imaginary doubt, would you struggle to follow an instruction that was different than that?
No.
Okay, I have no additional questions, Your Honor.
No questions.
Okay. And I do want to just be clear on that point then, for this juror. I did, in the beginning of what I was going through today with you, read an instruction, and it is the instruction that you would be given in this case. I just want to read that instruction again about what reasonable doubt, how it's defined in this case. And the instruction reads as follows. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from lack of evidence. And that's the definition part of that. Would you be willing to follow an instruction that is the standard you're to apply to the evidence in this case?
Yes, so using real tangible things.
Just that instruction, and that again is the definition, and you would be able to follow that instruction?
Yes.
Okay, I don't have a further question on that topic. Anything further from either side on that? All right, at this time then, without additional board hour on that, let's next take a look at the section of your questionnaire that is your attitudes regarding the death penalty, and where you've indicated you were operating on little sleep when you filled this out. If you don't mind turning to page 12 of your questionnaire. And so when you filled that out, you were just asking your opinions and attitude. Now that you are a prospective juror in this case, I'm going to advise you that it may in fact be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty in this case. And when you're considering that, you have to consider that it, as it should be done, any penalty you are considering should be considered as if it is absolute and would be carried out in the case. So with that context in mind, in your answers you stated right in the middle of that page 12, the question, do you support or oppose the death penalty? You said you would support. Is that the way you feel here today?
Yes.
Okay. If you please look then at page 13. You had a set of choices, 7, to accurately describe the way you feel about the death penalty. There's a mark there, I think closest to C. Am I to interpret that as C being your choice?
Yes.
Okay. C is a statement that says, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Is that the way you would feel about the death penalty still here today?
Yes.
All right. Are you in favor of the death penalty in every case where a murder has been committed?
No.
Okay, just one final question from me then. Are any views you have on the death penalty going to prevent or substantially impair you and your ability to be a juror in this case and to follow the court's instructions relating to the death penalty?
No.
Okay, that concludes my board diary on that topic. Does the state have a board diary?
No, I don't. Thank you, sir.
Any board diary from the defense? Okay, juror number 1185, that concludes your individual board diary. I'll have you return to the jury room with the bailiff. Thank you. We'll next talk to juror 1219. Will either counsel have an inquiry for 1219 on hardship or bias?
The stable, Your Honor. No, Judge.
Okay, thank you.
Judge, could I have just a minute? For some reason, it's not letting me back.
Yes,
May I have a moment for defense?
yes.
Yes. It's not.
It's, I mean, it's a large amount.
Got it, Judge. Thank
Okay, thank you. And we'll have juror 1219 brought in. All right, juror 1219 has returned. We have some additional questioning for you outside the presence of the other jurors. I believe you've got a copy of the questionnaire you filled out. If you do, would you please turn to page 12 of that? And that is the section of the questionnaire discussing your attitudes regarding the death penalty. When you filled out your questionnaire last week, do you recall thinking through these questions on the death penalty and providing these answers?
Yes.
I'm going to advise you in this case, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And when you consider it, consider that it should be done as if it is absolute and will be carried out in the case. When you're thinking about these responses, Knowing that, and with the time that's passed since last week, is there any change or amendment you would have to those answers, or would they still be true and accurate today?
No changes.
Okay, on page 12, you had a choice of do you support or oppose the death penalty, and you said support. Is that still your position here today?
Yes.
If you would please turn to page 13. On that page, you had a set of choices that describe the way you feel and what's most accurate. You picked C. C reads, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Is that still the way you feel about the death penalty?
Yes.
And you would be willing to follow any instructions about it in this case?
Yes.
All right, the next question I'll have then is, are you in favor of the death penalty in every case where a murder has been committed?
No.
Okay, and finally, I'll ask you, is there anything you think or we should know about your views on the death penalty that could prevent or substantially impair your ability to serve as a juror in this case and follow the court's instructions about the death penalty? All right, that concludes the voir dire of the court on that topic. Does the state have any voir dire?
The state has no questions, Your Honor. No questions, Judge.
All right, juror 1219, that concludes our individual voir dire with you. If you'd please return to the jury room with the bailiff, we'll call in another juror and let you know what's happening once we return you.
Thank you.
1271 will be up next. I know there was some tech issue here. Are the parties able to access that questionnaire? All right. So I don't know if it was advised with 1271. Okay, thank you. All right, juror number 1271 has returned for additional individual voir dire questioning. I'd note that this juror does have some case information and raised their card when asked if they did know something about the case. So we'll discuss that, and you can certainly openly discuss any facts you know about that here with the other jurors not present. There wasn't any indication that there may be a hardship, so I don't have any of my own voir dire in terms of bias. I'll allow the state to ask me questions about that, followed by the defense. So we'll do that for the state.
I will, Your Honor.
Go ahead, Mr. Wicks.
Thank you. Sir, in reference to what the court had just said, you had made some early responses that you do have some case information. Can you just kind of give us a nutshell of what you understand about this case before you came here?
Yeah, and I didn't know if it was the right time to ask the question, but I assume most people have some. That was kind of my take with it, is that I've just heard news clips, stuff like that. You know, there was, I've heard Lori Fallow, but the other person that you guys maybe mentioned was possibly a conspiracy. I don't know that name. I've seen a lot of like just news clips that have popped up on it.
On that point, I understood you said you didn't know this other person. Did you see or learn enough that you even remember the names of the victims, the alleged victims?
It kind of rings a bell. I hear it. I couldn't listen right now. I know that it's 2 kids. I know that just like random little tidbits that maybe Hawaii was in part of it or something like that, but not like I don't know a ton of details about the case. It's just I obviously have, sometimes sit and see news clips and stuff like that.
Did you happen to watch any documentaries like Netflix or
No.
anything like that?
No, no, it was just like it was just news clips that it was obviously a long time that the spam was unfolding. So it was just constantly like someone's maybe saying something like, "Oh, did you hear about that?" And that's about it. I just don't know the details.
Do you feel, based on whatever you did gather from what you're referencing, do you feel like you could set aside anything that you have learned and freely listen to evidence as it comes in and then be impartial in rendering whatever decision you might make as a juror?
Absolutely. Like I said, I don't know enough to even be like really put a stance on. So yeah.
Okay. The last question on this, on your questionnaire on page 19, you had noted, I don't know enough of what happened to form any ideas, and I also believe in innocence until proven guilty. What did you mean by that?
Just the fact that even, hearing it, I'm a firm believer in the fact that, like I'm just listening to random clips, like you really don't know the whole story until you sit down and go through it. It's just that's all I was saying. That's the little bit that I have heard absolutely doesn't matter until you sit down.
So is it fair enough to say that you're going to presume his innocence until the state proves him guilty?
Absolutely.
Thank you. No, I don't have any more questions.
All right. Questions. Okay. The next issue we'll discuss then, juror number 1271, relates to your attitudes regarding the death penalty. If you do have a copy of your questionnaire there, this is on page 12 and 13 where we're looking. And I am going to advise you that in this case, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And remember, any penalty you consider should be done as if it is absolute and will be carried out in the case. So thinking about that, you did provide answers here. Do you believe the answers you provided are still accurate in the way you feel here today?
Yes, yes.
Okay, absolutely. You were asked if you support or oppose the death penalty on page 12. You said you support it. Is that still the way you feel?
Yes.
Okay, on page 13, there was a series of choices, 7, that go into some more detail about what you think most accurately represents the way you feel. And you selected option C, which says, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Is that still representative of how you feel about the death penalty today?
It is.
Are you in favor of the death penalty in every case where a murder has been committed?
No, I'm not.
All right, and finally then, is there anything about your views or beliefs in reference to the death penalty that you think could prevent or substantially impair your ability to serve as a juror in this case and follow the court's instructions?
No.
Okay, thank you for your responses. Does the state have any more, Dyer?
We do not, Your Honor.
Nothing. All right, that concludes the board ire. Juror number 1271. We'll have you return to the jury room and the bailiff will give you further instructions. Next up will be juror 1288. And we'll have them brought in. Does council intend any more dire in this one in relation to hardship or bias?
Yes, Your Honor. This is a juror that we'd left off some questioning to pick up again during individual.
Okay, oh, correct, thank you. All right, juror number 1288, thank you for returning. We are reviewing your questionnaire here. There were some concerns raised in the group voir dire that state's going to ask about. In addition, if there's any other questions that could relate to a hardship, you can inquire there as well. The state can conduct individual voir dire with this juror, then the defense. Ms. White, is that you?
Yes, Your Honor.
Go ahead.
Thank you. Juror 1288, thanks for sticking with us. I know we'd had a conversation about graphic images and I said, maybe we'll pick it up in individual. So that's where I wanted to start with you. I know I kind of had put you on the spot and you may or may not have thought too much about it before coming in today. But I believe where we left off, and correct me if I'm wrong, but I think you did have concerns about your ability to view any images of that nature that you may have a reaction to, and then just weigh them in relation to other evidence. You probably had a little more time to think about it. Do you still have that concern?
I think I'm concerned about it. I think I want to be impartial and weigh it accurately. I do think I would struggle in associating that with my own personal situation. So that's.
Like we did talk about, and I won't get into specifics, but we did talk about you have some children. Do you think, because you've said you want to be impartial though, and obviously as you look at evidence and give it the weight you think it's due, you may weigh that out how you feel appropriate. Do you feel like something about seeing those images would make you automatically impugn guilt to the defendant without having heard before you've heard all the evidence and weighed it out? Would you automatically draw that assumption or conclusion, do you think?
I don't know if I would automatically assign guilt, but I think I would. I'd be a little emotional in my wanting to seek justice.
And that's fair. Do you think if instructed by the judge that you were to wait to form any opinion until having heard all the evidence and in reaching your conclusion, do you think you would be able to, even though you may have an emotional reaction, which is normal, do you think you would still be able to follow the court's instruction and wait until the end to make that final decision for yourself?
Yes. Yeah.
Thank you. I don't have any additional questions on this.
All right, thank you. Mr. Pryor?
I guess I just want to clarify.
Microphone, Mr. Pryor?
I'd like to clarify a little bit, if you don't mind. You see some graphic pictures, and I talked about that. You're going to have to block out having some sort of reaction and putting the blame on Chad. Is that what I'm hearing?
That I would have to block it out, is that right? Yes.
So in other words, you would be predisposed, or bad word, you would be upfront. If you saw these pictures, you would instantly say, I want to blame him for this. But you'd have to stop yourself and wait until you saw the rest of the evidence. Is that what you're saying?
I'm saying it would be difficult for me to not make an immediate emotional reaction of wanting to assign guilt to somebody.
And that's what, and again, I want to remind you, there's no wrong or right answer here. Because I really appreciate your honesty. I'm grateful that you're being honest. And so I'll restate what I said. You would have and I don't want to say extremely, but you would have a very difficult time not assigning guilt to somebody after looking at those pictures, and it would have an impact on you while you were deliberating. Is that fair?
I think so, yes.
And don't take this personally, sir. No, please don't. Judge, I'm gonna move for cause on this. I'm worried about the potential risk here.
All right, response from the state.
Your Honor, the state would submit to the court on this one.
All right, well, this is why we conduct these sometimes individually. Juror 1288, a few of those responses by sharing a concern of the defense that this is evidence that's likely to be admitted in the trial that may affect you in a particular way to shift a burden away from the defendant to which he's entitled. And so I appreciate you really thinking through. I can tell you very carefully considered your responses to these questions and believe that the challenge is best sustained in this point in our interest of trying to obtain the most impartial jury we can. So thank you very much for filling out your questionnaire and returning today. I'm going to sustain the motion to strike, and juror 1288 will be stricken for bias in this case. You can go ahead and go and return your questionnaire to the bailiff, and we'll move on to our next juror. Thank you. Let's talk to 1330. All right, juror 1330 is returned for individual for dire. Thank you for coming back in. We're reviewing the questionnaire now. And we're going to be asking you about the knowledge you have about this case in addition to possibly other topics. Because the other jurors aren't here, we wish for you to discuss this in as much detail as necessary to tell us what you know. And with that in mind, looking through the questionnaire and that you've acknowledged you have some case knowledge, I'm going to have the state begin with their individual voir dire as to any possible bias, and then we'll move on to the defense. Ms. Beatty?
Thank you, Your Honor.
Go ahead.
Good afternoon, ma'am. Hi. I just have a few quick questions for you about media exposure in this case.
Yeah.
So in your questionnaire, you indicated that you come across some news on TikTok, online, but that it just kind of come up. You hadn't sought it out. Is that accurate?
The only one I sought out was the Netflix special.
The Netflix special, okay. And you watched the Netflix special?
About a year ago.
About a year ago, okay.
So it's not completely clear.
Okay. Would you, and this might sound like an odd question, but would you kind of just tell us what you remember about the Netflix special?
I remember there were several suspicious deaths. I remember that seeing aerial footage of presumably the area of land that they were found. I remember seeing the last photo of them alive. That's about it.
And the area of land that they were found, do you know where that was?
Near Idaho Falls, I think, area.
Do you know who owned that property?
My understanding is that it was, the defendant.
Okay, so having watched that Netflix special, at the time that you watched it, did it cause you to form any opinions?
Well, I mean, everything you see on TV is formulated and produced for the benefit of the pockets of the people who own the TV.
So
I understand that. Now, would it sway me? Not necessarily, because they don't really care whether they're telling barely truth, half truths, approximate truth today's kind of thing for the sake of money. I wouldn't say that I'm personally swayed by anything I see online when it's a for-profit situation.
of course, I certainly appreciate that perspective. I did notice on page 19, when they asked if you could put out, when the questionnaire asked if you would be able to put out of your mind what you had read and heard, you'd initially check